I'm Lee Pacchia, and you are watching Bill on Bankruptcy. I'm joined now, of course, by the star of our program, Bill Rochelle, bankruptcy columnist at Bloomberg News and expert on all things related to the restructuring world. Lots of items to go through today, and Bill, I guess unless you've been living under a rock or in a cave with no access to internet or phone, you will not be surprised to hear that the story of the week is Hostess Brands Bakeries. They are the makers of Wonder Bread, of course. Bill, what can you tell us about this case that we don't already know?
I'm going to engage in what some people might call some speculation, but I think others might call it grounds for investigation in upcoming weeks and months.
Really?
First question I have is, in the bakery industry, there is probably too much capacity. And one wonders, could it possibly have been that the Bakery Workers Union thought that the best outcome for the entire industry and for their workers at other companies was for Hostess to go out of business, thus leaving less capacity in the industry and leaving the other companies not being badgered to give equal concessions.
So wait a second, you're talking here about a union actively sacrificing its constituents?
That's the question.
Huh.
Very much
Haven't seen
worth,
that
I
before.
think, investigating. I'd say it's an outside chance that it could have occurred, but this is a very strange situation where you see basically workers committing suicide, which is what actually is going on here. Another question I have really looks at the other side, because I'm going to be very, shall we say, universal in laying out questions that are worthy of investigation. And that is, did management of Hostess figure the company was dead already? And therefore, since the union went on strike, they could conveniently pull the plug and blame the union, and thus avoid a nastier situation some weeks in the future where they have to pull the plug on themselves. Also, by the way, back early this year, the company had a new and very fine CEO named Driscoll. He up and quit suddenly without explanation. I've always wondered, why did he quit? Could it have been because he figured the company could not survive? This, Lee, is just such an odd situation that I hope there is a thoroughgoing investigation on both sides. And believe me, I'm not trying to point the finger one way or the other. I would just like to find out, why did this catastrophe happen?
Bill, I got to ask, do you think, what are the chances of us seeing an investigation of either of those issues that you just drew out for us?
It is not, shall we say, typical in courts in New York or Delaware to hang out a whole lot of dirty laundry. So I'm not sure that we're going to see it here. Although one wonders if there will be a request for an examiner at some point.
I'm surprised we haven't seen one already, I got to say.
Well, this is New York and Delaware, or Delaware. It's New York, but I mean equally true in Delaware that examiners, trustees are disfavored.
Speaking about antagonism between labor and management, American Airlines has been a hotbed for these types of disputes, toxic labor relations, of course. Yet the company continues to fight with its passenger service agents. What's the story here, and where is this heading?
Again, this is something that doesn't quite compute. The passenger service agents at American Airlines are the one worker group that are not unionized. The National Labor Relations Board believed that there were enough workers who wanted a union to call an election. American didn't think there were enough. American thought it should have been 50% to sign the cards. And American took them to district court, federal district court in Fort Worth, and won, blocked the election. The workers appealed to the Fifth Circuit, and there they won, reversed the district court, and got an order directing an election. Now, one would figure at this point, with American in some touchy negotiations with its creditors now, including its labor, that they would simply roll over and go forward with the union election. But no, American has said that it wants to appeal to the U.S. Supreme Court to try to block this union election. And I'm just wondering, is this, shall we say, the best strategy to undertake for a company that has had recent historically poor labor relations?
Turning now to the Judge of the Week. It deals with cross-border bankruptcies. It's a topic that's been really hot lately. We're waiting on a decision to come down in the Vitro case, the huge Mexican glassmaker that has bankruptcy proceedings all around North America. We also saw the big opinion come out of the UK Supreme Court. The opinion's a big opinion punching a hole in the idea of international cooperation in general. And now Delaware bankruptcy judge Sanchi came down with a decision that has piqued your interest. Why is that?
It's a wonderful decision, very well written by that judge in Wilmington, Delaware. He again is punching a hole in the notion of international cooperation. In the Elpida case, he was asked basically to rubber stamp a decision by the main bankruptcy forum in Japan approving a sale of technology in the United States. The company basically told him, Judge Sanchi, you don't have any choice but to approve it because the Japanese court already did. And he said no. He said, I, under the statute, have an obligation to apply the same standard to approval of this sale as I would if this were a company completely in bankruptcy in the United States. This is yet another hole in the notion that if you have a lead company or a lead country in a bankruptcy case, everybody else simply follows suit. It ain't turning out that way.
We briefly mentioned Kodak last week. In order to make up for their $500 million loss since filing its Chapter 11 earlier this year, they struck a deal for a $793 million loan. But Bill, you think that number is not all it's cracked up to be. Why is that?
Not quite. Because part of that nearly $800 million is the conversion of $375 million of second lien debt to what really amounts to first lien debt. In other words, for putting up $400 million, the lenders are, shall we say, bootstrapping debt that is, shall we say, questionable, may not be paid in full, up to a level where it will be paid in full. This, I think, is a really nifty little transaction here, one that hasn't not yet come to court for approval, and it will be quite interesting to see how it goes down. This is just one of those games that Wall Street plays where people who, shall we say, have a difficult position try to improve their position by a fancy financial transaction.
And I guess we have a little bit of a want ad section. In our recent videos, we've been, or you've been kind of talking about how the idea of getting smaller isn't necessarily the prescription to becoming more profitable. Shoe retailer Baker's Footwear is going to try that approach nonetheless. How does it look?
Well, I can't wait to see 3 years from now how it works out. Baker's has liquidated 150 stores, and it is going to continue operating 63 stores. In other words,
not a tiny chain.
Yeah, they are, and they're even tinier now. This really will be a good laboratory experiment on whether or not getting much smaller will make you profitable.
Time for some advance sheets. We have 3 cases, one from Atlanta, one from New Orleans, and one from Delaware. Tell us why they're important.
Well, the first one is important for lawyers. Let's assume you have a reorganization plan, which gives a complete release to lawyers. Yet sometime after confirmation, somebody sues a lawyer to make that lawyer disgorge because something that should have been disclosed wasn't. Well, guess what? The 11th Circuit in Atlanta, Georgia, ruled that the release in a plan is not a bar to a disgorgement. So I guess it means that releases in plans ain't all they're cracked up to be. The second case comes from a Delaware district judge, Sue Robinson, and because it's from Delaware, it therefore is important in reorganization cases. Basically, what she's saying is that there is no blanket prohibition against investor lawsuits in Chapter 11 cases. This is called Cottonwood Partnership, and I think anybody who practices in Delaware ought to read it. Finally, we go to the Fifth Circuit in New Orleans. The latest decision is in a line of cases having to do with specificity that must be given before confirmation about lawsuits you intend to bring after confirmation. This newest decision is called Compton versus Anderson. It's in the line of cases that include United Operating and Texas Wyoming Drilling. If you practice bankruptcy law in the Fifth Circuit, that is a case you need to read right away.
All right, Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.